Be ready. Start. Custom forms a dominant feature of the civil litigation in the Punjab. Section 5 of the Punjab Laws Act 1872 lays down that in all questions regarding successions, special property of females, betrothal, marriage, divorce, dower, adoption, guardianship, minority, bastardy, family relations, wills, legacies, gifts, partitions, or any religious usage or institution, the rule of decision shall be custom when there is any custom applicable to the parties, provided the custom is not contrary to justice, equity, or good conscience, and has not been altered or abolished by any statute or declared void by any competent authority. In other cases, Mohammedan law in the case of Mohammedans and Hindu law in the case of Hindus is to be applied. The vast majority of the rural population in the Punjab follow custom. It is the exception rather than the rule for the Hindu and Mohammedan law to be applied in their entirety. The ascertainment of custom, when it is disputed, is often a matter of difficulty. The records of tribal custom prepared by government officers for the various districts are helpful and are accepted prima facie as good evidence of the customs stated therein. In view of the wholesale migrations of population after the partition of Punjab, the question may often arise whether a person is governed by the customary law of home of origin or of the land where he has settled down. The consensus of authority is that persons or tubes may be presumed to be governed by the customs of their original home and not by the customs of the land where they settled down, unless it is shown that in any matters they have adopted the customs of their new habitation. The presumption is, however, rebuttal on proof of special circumstances. When in any particular instance no rule of custom can be found, the court must fall back upon the personal law of the parties. The provisions of Punjab Act 1 of 1920, which prescribes the limitation for suits relating to alienations of ancestral immovable property and appointments of heirs by persons who follow custom, and Punjab Act 2 of 1920, which restricts the power of descendants or collaterals to contest such alienations or appointments, should also be studied. Some features of money suits deserve attention. The typical money suit in the Mufassil is one between a creditor and an illiterate debtor. The suit is generally based on a running account consisting of petty items in the account book of the former, with balances struck from time to time, or an agreement recorded in it with regard to larger loans borrowed on occasions of marriage, etc. Thank you.